Welcome, everybody, to this session on cross-cutting issues in e-commerce and digital economy, intellectual property, and MSME development. I have the warm pleasure of greeting all our expert panelists and speakers in this session. Let me begin by introducing them very briefly. We will be having two lead presentations. First by Mr. Hideyasu Tamura, Senior Director, Economic Partnership and Regional Integration, Ministry of Economy, Trade and Industry, Japan. This will be followed by Professor Henry Gao, Associate Professor of Law, Singapore Management University. Following the lead presentations by both speakers, we will be having a panel presentation and discussion. We have four panelists. Ms. Carrie Suen, Senior Advisor, International Public Policy and Government Affairs, Ant Group. Ms. Alpana Roy, Singapore's Senior Economic Official and Director, ASEAN, Ministry of Trade, Singapore. Mr. Joseph T. Yap, former President, Philippine Institute for Development Studies, and Mr. Man Hung Tran, Managing Lawyer, Baker McKinsey. The instructions are as follows. We'll basically be having about 10 to 12 minutes of the presentations. The panel presentations will be for around 8 to 10 minutes for the first round, and then we will open up to discussion among the panelists and then take questions from the floor. So thank you very much all for attending, and I have the pleasure to first invite Mr. Hideyasu Tamura for the lead presentation. Thank you.
Yeah, thank you very much. This is Tamura from Japan's Ministry of Economy, Trade and Industry. And my greatest pleasure to have this kind of opportunity to make some presentation here today. And so this is just a kind of brief presentation from me. And as I was involved in the RCEP negotiation from the very beginning phase and the final phase, I mean, from 2018 to 2020. So from those kind of experiences, I wish to make some presentation as a background. So can you scroll to, yes. And in the yesterday's session, several presenters or speakers touched upon the history of this RCEP negotiation. So it's not my intention to get into the details, but it started from the very early 2000s, like say, when China proposed the idea of ASEAN plus 3 kind of free trade area concept, and Japan followed with ASEAN plus 6 membership EPA as a kind of the track 1.5 or track 2 studies. And the turning point for this arrangement or agreement was in 2011 when under the Indonesia chair countryship, ASEAN countries proposed a so-called ASEAN framework for the regional comprehensive economic partnership. And in the next year, 16 leaders agreed on a kind of launch of the RCEP negotiation with the release of the RCEP guiding principles and objectives. And at the time, back in 10 years ago, the scope of the RCEP, or indicative scope of the RCEP was quite limited, and goods, services, investment, and intellectual property and competition were the only two issues or areas which was clearly stated as a negotiation scope. But getting to the next slide. Yes, and after the subsequent negotiations, it became a much wider scope EPA or Regional Comprehensive Partnership Agreement, and it now includes 20 chapters, including not limited to intellectual property competition, but on the e-commerce, government procurement, and small and medium enterprises promotion. And during the course of the negotiation of the RCEP agreement, it was in parallel process with the CPTPP or TPP. So several countries, including Japan, which joined both of the TPP and RCEP negotiations, proposed to include or incorporate some of the elements which were in the TPP, but not in the original scope of the RCEP. And it is because, of course, to be frank, Japan is not a kind of dogmatic promoter of the high standard rule, but from the viewpoint of businesses, like say the freer flow of the data or information in this region is becoming more and more important, and also the protection of the intellectual property and securing the level playing field by including meaningful competition chapters or provisions becoming more and more important. So we propose that kind of provisions and chapters to be incorporated in the RCEP. That's the background. And as a result, we successfully concluded these 20 chapters agreement, even despite some of the unexpected things like the withdrawal of India in the final phase of the negotiation, and also the COVID-19 and COVID-19 crisis. And it was quite a miracle that we concluded this negotiation. Even the final year, I mean 2020, we could not organize any of the physical meetings, and every level of the meetings, including leader summit and ministerial and our levels of official meeting, all of them are organized in virtual format. And but it was quite successful. And if you could look at the next page, I specified several examples of the important rules for the businesses in the RCEP agreement. And one of them is a protection of the well-known trademarks in Chapter 11 of the intellectual property rights. And sometimes protection of intellectual property rights are associated only with the protection of the interest of the big companies that were multinational corporations. But the fact is a bit different. And because especially from the viewpoint of the Japanese government, now Japanese local businesses, including those from the rural areas of Japan, were some of them associated with agriculture or fishery sectors, are now aggressively expanding their operation to Asia Pacific region. And as a result, many of those businesses are facing some sort of difficulty and infringement of the well-known trademarks. And one example is here, and right one on the screen, Imabari Tower Japan is actual trademark registered in Japan, and the left one is quite similar, but it is a kind of fake trademark registered in some of the also participating country. So this kind of protection on the trademarks in RCEP region is quite indispensable for the SMEs operation, in regional operation of the SMEs. And so this kind of rule stipulated in the RCEP agreement could have the significant meaning for not only for big businesses or multinational corporations, but as well for the small and medium enterprises. And next page. Yes, another example of the very significant rule is electronic commerce, which is another big topic for today. And one big characteristics of the RCEP agreement, e-commerce chapter, which is the chapter 12, is that we successfully incorporated some rules on the cross-border transfer information and the prohibition of the location of the computing facilities in this particular agreement. And of course, there is some kind of legitimate public policy objective exemption in this agreement. There are several, very important components included this kind of chapter. And like I say, here you can see that this is one example, and this is the case of the Japanese new startup operating regionally in several ASEAN member states. And the company wish to exchange data from which they gathered in one ASEAN member states, like I said, in Thailand, and utilize those data in other. And yes, those companies wish to use the data gathered in Thailand in other countries as well. So that kind of cross-border information free flow, is quite indispensable for them. And but for these companies, one big bottleneck is like say some sort of so-called data protection in several of the countries, like say in the form of the cybersecurity law or regulation on the privacy, that could impede the smooth transfer of data in the cross-border manner. So for those companies, free cross-border in data flow in accordance with RCEP ECommerce chapter is so much expected. And so for those companies, viewpoint, through implementation of the RCEP agreement, not limited to the liberalization side, but also for the enforcement of rules is quite important. And so in the first RCEP joint committee last week, for supervisory bodies was successfully established, and RCEP secretariat function should be developed accordingly. And in addition to that, general review of the agreement will be conducted after 5 years of the entry in force. So in those kind of review process, the implementation issues and some of the missing parts, like say state-owned enterprises, labor, and the source code in the e-commerce chapter, those kind of elements should be further considered for the development of the agreement. But what I want to stress is that implementation and enforcement of the agreement by all the parties is a first priority thing. And we should work with ASEAN member states as well as with other ASEAN FTA partner countries towards that kind of goal. This is my brief presentation. Thank you very much.
Thank you very much, Mr. Tamura. We now move to Professor Henry Gao.
Thank you, Rupa. I want to start by thanking the ADB for kindly inviting me to this conference. It's my pleasure to join the conference and share some of my views on the e-commerce chapter. So let me start by sharing my slide. So as we all know, for the regulation of e-commerce in free trade agreements, it was a trend that started with the United States. And the US started with the regulation of e-commerce in its free trade agreements with Jordan, which was concluded in 2000. Since then, the US has included e-commerce provisions or even chapters in almost every free trade agreements with the TPP, later known as the CPT, as the leading example. So the RCEP made new programs, as Tamura-san mentioned earlier, by including e-commerce, but there are many concerns that the e-commerce standard in the RCEP is lower than the CPTPP. So today I'm going to compare the agreements in the provisions in the two agreements to see how does the RCEP fare compared to the CPTPP. And as you can see here, I listed the articles under the CPTPP to the left and the RCEP to the right. The CPTPP has 18 articles on e-commerce and the RCEP is 17 articles. Most articles are similar, except some articles which are contained in the CPTPP, which cannot be found in the RCEP, and I've highlighted them in red here. So if you look at the ones in red, these include the provisions on non-discriminatory treatment of digital products, principle on access to and use of the internet for electronic commerce, internet interconnection charge sharing, the provision on source code, and also another difference is that the CPTPP has included dispute settlement for e-commerce, but the RCEP has excluded the e-commerce chapter from dispute settlement. But the RCEP, interestingly, included one provision which cannot be found under the CPTPP. This is a provision on transparency. Now, if you compare the two agreements and if you look at the differences, you can see that the US provisions, for example, these two provisions in the middle, principles on access to and use of the internet for e-commerce and internet interconnection charge sharing, these were actually taken, for those of you who are familiar with the WTO General Agreement on trading services, or the GATS. You can find this under the telecommunication reference paper. So basically, these were the provisions which were copied from the reference paper on telecom. to make sure that the US firms, when they operate abroad, they would have access to the internet, and also they would not be subject to exorbitant charges on the internet for providing their services. Most other provisions are very similar in the report on the digital economy integration that was published by the ADB earlier this year. As you can see, actually, was divided into a total of 4 different categories. I consulted the ATP on these issues. So as you can see, these 4 different type provisions. The first one, I would call them the ones dealing with e-commerce infrastructure issues. So these include issues on, for example, electronic signature, authentication, contracts, and also e-commerce trade facilitation measures. The second type are the regulatory barriers issues. So for example, on free flow data, cross-border data localization requirements. These are the main demands of the US. And the third category are the provisions that dealing with consumer trust issues. These include provisions on personal information protection, privacy, and so on, which has been a main concern of the EU. And the last provision, last type of provision, are those dealing with the regulatory autonomy issues. And this has been the main concern of developing countries such as China. So if you compare these 4 categories of provisions across the different trade agreements in the region, you can see that the first one is the most popular. So most of provisions include the provisions dealing with the trade facilitation and e-commerce infrastructure issue. That is because they are largely uncontroversial and largely just reconfirms existing provisions in the existing agreements, such as the WTO's Trade Facilitation Agreement. And then categories 3 and category 4 are the second most popular provisions, because these provisions are also, for example, the ones on regulatory autonomy, on consumer protection, also relatively less controversial. So most agreements would include them. But the second category, that is those ones which deal with the regulatory barriers, are the least popular among the free trade agreements in this region. And that is largely because for most countries, they have concerns over these issues. And that is also reflected in the RCEP. So next, let me focus on the provisions which are found in the CPTPP, but which cannot be found in the RCEP, and see whether these provisions really include meaningful new commitments. The first one, as I mentioned earlier, is non-discriminatory treatment of digital products. So if you look at this provision, what this provision does is basically to make sure that the digital products are produced by FTA partner will not be discriminated against in another country. Now, this again confirms the interests of the US digital firms such as Facebook, such as Google, where they provide services across the border. They have concerns that they might be subject to discriminatory treatment. And also, if you look at the way the CPTPP defines what are digital products, as you can see, the digital products are defined quite broadly, and they include basically all these kind of new digital services that you can think of. And again, they are in here to protect the interests of US digital firms. Now, the other provision is on cross-border data transfer. This one, as I mentioned, has been the stable provision in the US free trade agreements. You can find this provision and the prohibition on data localization requirements in all of the recent US trade agreements, basically in the past 10 years. So these two really also reflect the interests of US businesses such as Google and Facebook, which have to be provided on a global basis rather than having to set up the server and the data centers in every country of operation. Now, interestingly, here you can find that the RCEP also include provision on cross-border transfer of information, which is largely copied from the CPTPP provision with some interesting difference. And the difference here is really in the latter part of the RCEP provision, the part where I highlighted in yellow, where you can see that here the RCEP explicitly include a provision which allows the RCEP members to adopt measures which are inconsistent with the free flow of data if it considers necessary to achieve a legitimate public policy objective or essential security interests. These language are basically the same language as under the WTO's general exception and the security exception clause, and they are copied into the RCEP specific to this provision to make sure that the parties' regulatory autonomy would not be undermined because of a commitment on this provision. Similarly, you find also similar provision when it comes to the provision on data localization, and that is really interesting, even though it also incorporates similar provisions under CPTPP. I mean, if you look at the CPTPP also has exceptions clauses, not specific to the e-commerce chapter, but contained in part of the overall framework agreement. And you can also cite to these provisions. But the difference between the CPTPP and the RCEP is that the RCEP gives more leeway to the member invoking such an exception, because as you can see, I highlighted here, whatever is necessary would be decided by the member invoking the exception, what it considered to be necessary. And these basically give the members more freedom in deciding what to do. Another provision which was contained in the CPTPP but not in the RCEP is a prohibition on forced transfer of the source code. This provision has been very controversial. Other than the US FTAs, there has been very few FTAs containing such provision. Now, let's come to the dispute settlement provision. For the dispute settlement provision, the CPTPP provides that, other than some exceptions to certain specific countries like Malaysia and Vietnam, for a transition period, the other CPTPP members are all subject to dispute settlement for the e-commerce chapter. But the RCEP exclusively carve out the entire e-commerce chapter from dispute settlement. And that has been criticized by many external observers to be insufficient. But I have a different view here. I think that the very fact that the members of the RCEP was able to include a provision on, for example, free flow of data and also prohibition on data localization requirements is a big progress, because that is actually the first time that big members such as China have agreed to such provisions. So I think that itself is already a very good start. And that is encouraging news if we look at things in a broader perspective. So thank you very much. I will stop here. I look forward to our discussion. Thank you.
Thank you very much, Professor Gao. I think we've had two excellent presentations. The first highlighting the importance of business rules and specifically looking at issues like IP. And the second, which has provided a great comprehensive sort of comparative analysis of the CPTPP provisions and the RCEP provisions, and perhaps highlighting a bit of the lower level of ambition, but the fact that we have made progress in ensuring certain provisions were included in the RCEP agreement. So thank you very much to both speakers. Now let's move to the panel discussion. Our first panelist is Ms. Carrie Suen. Ms. Carrie, you have the floor.
Thank you, Ms. Rupa. Hi, everybody. Good afternoon. It's a great pleasure to be here and join the group on discussing the prospect and future that RCEP can bring to the real economy. So I would like to start by just expressing this initiative, this agreement, this regional forced task is very encouraging and very timely. The global supply chain has been hugely disrupted over the past 2 years. And I guess before we haven't really felt how vulnerable the global supply chain could be. And hugely, we can see at the end of the day, it's really the small, medium enterprises that have been suffering from the pandemic effect. And right now, there's more urgency to look into this regional framework and see how we can bring the public and private partnership much closer in implementing. So RCEP itself, set out 20 chapters, how the region countries can work together on facilitating the cross-border trade, especially which is worth highlighting is how to leverage digital payments and financing to help all these businesses to do business much more simpler and seamlessly cross-border. Having that framework, it's very important because without the public sector involvement, the recovery will be a long way ahead. And how can we do it possibly? Having that framework as a start is important. I think whether it's trade, whether it's e-commerce, whether it's custom clearance, we cannot ignore the fact that payments itself is an important pillar of that equation. And the RCEP set out a framework how the participating countries can adopt more openness in enabling new financial service provider to utilize the public infrastructure in clearing and settlement in different countries, and how to increase the transparency across border as to how new framework, new rules will come into place, and more importantly, how we can help make these businesses to leverage these infrastructure and encourage more participation from different types of service provider to bridge the gap, in areas such as credit, such as insurance, such as factoring, and having the state encouragement to bring in more credible players who have the financial expertise to provide the services is important. So as a company, we definitely very welcome this approach. So we can look into the practical aspect of how this economy has evolved over time. RCEP involves 10 ASEAN countries, plus China, Japan, Australia, New Zealand, and Korea. So just looking at Southeast Asia, 6 countries alone, by 2025, the e-commerce and the digital development, including health tech, ag tech, that whole space, we will have a projection of up to 360 billion USD GMV. So that number will not be ignored. And then with the pandemic kicking into place, now we see a cashless adoption is a prevailing way of making digital payments to resolve the essential needs of our consumers in these markets. For example, Indonesia alone by 2025, the projection is to have mobile users more than 200 million. And together, there's a transaction size that we project will be more than 107 billion USD. So that is a very sizable market that we can already foresee. So what I want to emphasize is the importance of leveraging the RCEP framework to bring the trade where the consumer needs are. So just taking a step back, as a company, we started in 2004. I think what really gave us the initial start is to bridge the trust between buyers and sellers on e-commerce platform. Now it sounds very familiar to everybody. Everyone shops online. Everyone, pays sellers across different countries without knowing who they are based on the platform feedback and framework that they provide. But back in 2004, we can imagine this is a very, very foreign space for a lot of the consumers that have never made purchase online in China. So we started from a very humble start, really just to see how to facilitate that trade between a buyer-seller and the normal ordinary course of business. And that trust to be very important missing piece. And from there, we have been really observing where the consumer needs are, and then we evolve one step at a time, and then we start servicing consumers in consumer loan, in insurance, in wealth management, etc. So trust is definitely something that we cannot just replicate easily, but takes time to accumulate. So that's why, you know, having that framework again is important, but also cannot underestimate the involvement of private sectors who can bring digital expertise onto the table as well. So how do we do it? Right now, I think if we look from the SMEs angle, there are many challenges. Right now, SMEs don't have digital identity in a sense that when somebody from Australia wants to buy from Brazil, they don't know the background of the supplier in Brazil. So it's very hard for a buyer to take that first initial step to transact cross-border from somebody they don't know of. So having that identity, having that validation is very important. And also credit risk. Right now, a lot of banks, especially in the time of pandemic, it's very risk averse for them to extend credit to suppliers who may not be able to make the trade cross-border because of all sorts of issues. So having that credit risk system, leveraging public infrastructure, leveraging government involvement is very important. And how do we resolve dispute cross-border? As the cost increases, it also discourages people from trading cross-border. So what I would like to hope to provide a key takeaway from today's discussion is, you know, RCEP definitely is a very important initiative, but how to implement them and make sure we have an inclusive ecosystem where SMEs and people who actually need the service, need the trading facilities, will get access to the market. So that's why I would highly recommend having more closer public-private partnership to come to place to look into the implementation process to make sure the process flow is easier, leveraging technology, leveraging financial expertise from different providers, so we can make the SME journey much simpler, such as having digital wallets, having blockchain to look after the end-to-end trade financing flow would help. So I would like to end my presentation here and would look forward to hear any questions you have. Thank you.
Thank you very much, Ms. Yuen. Our next panelist will be Ms. Alpana Roy from Singapore's Ministry of Trade.
Thank you very much. First, my thanks to the Asian Development Bank for the opportunity to be here today. For this session, I intend to focus on the digital economy. I think the substance and provisions of the RCEP's e-commerce chapter have been very well covered by our previous speakers, so I won't delve too much into that. But I also thought it equally important to contextualize RCEP's place amongst ASEAN's broader efforts to harness the potential of the digital economy. Let me do a quick, brief backdrop. I think we all know it's been more than 2 years since the pandemic ravaged the world, and its impact is being further exacerbated by a perfect storm of geopolitical complexities and tensions, continued protectionism, structural economic shifts and pressures, and the urgent need to address problems on a global scale, such as sustainability. But despite this, the region continues to remain a strong beacon for growth. And further, RCEP's entry into force this year is a strong testament to the region's continued commitment to deepening economic integration and cooperation in its difficult times. Let me also now touch briefly by way of backdrop again on the ASEAN region's tremendous potential for digitalization. And just to quote 2 or 3 data points, Southeast Asia is one of the fastest growing internet markets in the world. Its internet economy is projected to reach US $360 billion by 2025. I think even more important is that the speed of digitalization also increased exponentially during the pandemic, with 75% of the region's population now online. The ASEAN region has been harnessing the potential of digitalization at multiple levels. So you would have seen a proliferation of B2B, B2C, G2G initiatives and efforts, and so on and so forth. But for today, let me focus on the G2G level, and in particular, what ASEAN as a platform continues to undertake in the digital space. In fact, I think there's no dearth of digital economy initiatives within ASEAN, and some actually may view this as rather confusing. So let me attempt to simplify these various efforts into three broad constructs. First, frameworks. Second, rules, which is where RCEP comes in. And lastly, collaboration and capacity. First, on frameworks. ASEAN has a range of organizing frameworks with a common goal, namely regional digital integration. And I will name just some of them. For example, the Master Plan on ASEAN Connectivity 2025, the ASEAN Digital Master Plan 2025, and the Bandar Seri Begawan Roadmap on digital transformation. Now, each of these establish ASEAN's path forward digitally with an emphasis on different areas. The specific initiatives within each of these roadmaps and master plans are comprehensively captured in the ASEAN Digital Integration Framework Action Plan, or DFAP. And simply put, the DFAP acts as an overall blueprint for regional digital integration. It was deliberately designed to be comprehensive, flexible, and have longevity as it is reviewed regularly to ensure initiatives are non-duplicative, relevant, and effectively address identified needs. Second, let me move on to the area of rules. And here is where RCEP plays a part. It is critical that ASEAN establish common rules and policies to address digital issues and foster interoperability with its partners. This is especially salient as technology has become an increasingly contested space globally. The RCEP e-commerce chapter is hence a forward-looking step in progressive rulemaking and engendering a more conducive and seamless digital trade environment in the region while safeguarding consumer interests. Broadly, it seeks to do this by establishing disciplines to support cross-border trading goods and services, as well as cooperation. One example is paperless trading, where RCEP countries are obliged to accept electronic versions of trade documentation for customs clearance, thus reducing processing times, increasing efficiency, and keeping costs down. But RCEP's critics may question the ambition of the agreement. A pragmatic and realistic view, however, is that some RCEP countries require policy space in the digital economy amidst a rapidly evolving digital world. I think fundamentally pulling together 15 very different countries at very different stages of regulatory development into a rules-based e-commerce chapter is no small matter. And there's a potential for this agreement to be reviewed further. I think one often less known fact is that predating the RCEP e-commerce chapter is ASEAN's own agreement on e-commerce. And arguably, ASEAN negotiating the RCEP e-commerce chapter would have been much more difficult and time-consuming without its own e-commerce agreement in place. With RCEP under its belt, more importantly is what lies ahead for the region in digital economy rulemaking. I think to this end, ASEAN has committed last year to establishing digital trade rules and digital economy collaborations via an ASEAN Digital Economy Framework Agreement, or a DIFA. And to keep pace with digital technology, it is imperative for ASEAN to maintain momentum towards launching DIFA negotiations soon. This is critical to not only ASEAN's continued centrality and relevance globally, but will also be key to the region's aspirations for inclusive and sustainable growth. And lastly, let me touch on collaboration and capacity. What is perhaps less known is that ASEAN has embarked on a wide range of discrete or standalone collaborative digital economy initiatives spanning various modules such as trade facilitation, standards, digital identities, transport, science and technology, payments, agriculture, and a number of other areas. Now, the pace and modality of these collaborations vary. Some areas are more nascent, while other areas are more mature or have been implemented. As for the modalities, some initiatives are binding, while others are more cooperative in nature. Some involve pilots among some ASEAN countries, while others involve all 10 of us. This is practical, given ASEAN's composition. Now, underpinning ASEAN's efforts in advancing the digital economy is realizing benefits for our businesses, especially micro, small, and medium enterprises, or MSMEs for short. This is why a critical component of ASEAN's efforts to accelerate digital adoption is robust capacity building, such as upskilling and reskilling initiatives, amongst others. Apart from the RCEP MSME chapter, ASEAN has also created a pool of national and regional digital experts and mentors to provide business advisory services to MSMEs, amongst other efforts. For example, in 2016, a ASEAN task force on starting a business was set up to address concerns of MSMEs seeking to regionalize, such as cross-border and digital identification, amongst others. And you will find such capacity building efforts in a large part of ASEAN's digital economy initiatives. Singapore fully supports ASEAN's various digital economy efforts, and to complement this, we have been continuing to pursue digital rule making and connectivity through digital economy agreements. And the idea of these agreements is to facilitate seamless end-to-end digital trade, enable open and trusted use of data, and build trust in digital systems. To conclude, rather than viewing each of ASEAN's various digital economy initiatives, such as the RCEP e-commerce chapter, on their own, it is important to recognize that each has a role to play as ASEAN progressively advances work on the digital economy. ASEAN and its partners hence need to not only build on RCEP, but also build on ASEAN's various digital initiatives to boost our economies during these challenging times. Ultimately, at the heart of each agreement and initiative is our businesses' needs and how to make them relevant and accessible for the businesses, as well as meeting the aspirations of our populace. With the RCEP's entry into force and ASEAN's various efforts, we hope companies will tap on them and be better equipped to learn about them in pursuing opportunities in the region. I wish all of you fruitful discussions ahead, and thank you very much for the opportunity once again.
Thank you, Ms. Roy, for your intervention. We now move to Mr. Yap, who's our next panelist. Mr. Yap, you have the floor.
Thank you, Ms. Rupa Chanda. Everyone can hear me. Excellencies, distinguished guests, ladies and gentlemen, good afternoon. My gratitude to the Asian Development Bank for inviting me to this important conference. I start with the statement, I hope not too controversial, that economic integration in the region in East Asia is presently being driven by digitalization, and the pandemic has been a contributing factor. Yesterday, Mr. Alfredo Perdiguero stated that one way for ASEAN to benefit from RCEP is a greater application of digital technologies on trade. This is an example of behind the border issues that have to be considered. The question that is relevant that we can discuss today is how can RCEP members harness this potential? Should it be a top-down approach or region-wide approach, or should individual countries take the initiative in what we could describe as a bottom-up process? We more on this later. So the next two slides are diagrams that from publications by the Asian Development Bank. This shows the scope of the digital economy or the digitalized economy from narrow to a broad scope, and then the next shows the revenues from digital platforms, which is a subset of the digital economy. So in 2019, revenues of digital platforms were $3.8 trillion globally and $1.8 trillion in Asia. So we can analyze this issue, whether should it be top-down or bottom-up, based on a publication by PECC, which is titled here. It's a primer on economic integration issues posed by the digital economy, and it's very appropriate for ASEAN, RCEP, and even GMS. So this is a reference to help organize issues. So in this primer, two general areas are identified. First, you have the digital economy, and then second, you have digital trade. So the demarcation is roughly digital economy is focused on domestic issues, and then when we have cross-border implications, then you have digital trade. So a useful way to frame each of these issues. So for example, in digital economy, you have issues like cybersecurity, competition policy, consumer protection. In the case of digital trade, you have data sovereignty issues, data transfer mechanisms, some of which were discussed earlier. A useful way to frame these issues is through a matrix. You have on the first column the different areas, and then the first row shows the different countries. By the way, ASEAN, I actually mean the 10 individual member countries. This is just a way to make the presentation less messy. So for example, in the area of cybersecurity, a question is, would regional cooperation through RCEP be the main tool to achieve a certain threshold or standard in terms of cybersecurity? Or because of development gap in the region, particularly in terms of institutions and governance, should we focus on individual countries? So yesterday, Ms. Vitada made reference to a possible trade-off between regulatory similarity and compliance costs. I hope I understood her point correctly. So if it would be bottom-up, the question is, what would be the main activities in each country? This is what would fill up the individual cells. So for example, if it's bottom-up, then we have to decide what each ASEAN member country should do in terms of cybersecurity, what policies, what institutions, etc., should be established. So as an example of these activities, based on the presentation of Pramila Crivelli yesterday, RCEP countries can benefit from countrywide research and capacity building. So in the context of digitalization, these activities will be different for different countries. So no one size doesn't fit all. So a regional approach is obviously more appropriate in the area of digital trade. For example, RCEP provides a comprehensive chapter on e-commerce. Okay, so Mr. Gao gave a comprehensive description of what is involved. E-commerce is actually one of the many sectors as opposed to areas that can be classified as cross-cutting issues. Cross-cutting means that both the digital economy and digital trade are relevant. The other examples shown in this slide are digital payments and online travel. Other cross-cutting issues involve areas like closing the digital divide. And what is more important actually for this particular session is the digitalization of businesses, big and small. So one question can be asked if RCEP would be the more useful channel to improve the capacities of SMEs. Should the focus be on individual countries? Again, this is a case-to-case basis. One size does not fit all. One final point I would like to make is that the bottom-up approach can comprise a subset of countries. Examples are the Digital Economy Partnership Agreement involving New Zealand, Singapore, Chile, and the Digital Economy Agreement, an amendment to the Singapore-Australian FTA of 2015. With that, my usual thank you in East Asia. Terima kasih banyak.
Thank you very much, Mr. Yap. You've raised some very important questions actually in terms of the approach and the point that you made regarding not one size fits all, whether one takes a regional or country approach depends on the issue as well. So thanks a lot. I think we can come back to this during the open discussion. Our last panelist is Mr. Man Hung Tran. He is a managing lawyer of Baker McKinsey. So the floor is yours, Mr. Tran.
Thank you. Can you see my screen?
Yes, we can.
Yeah, I hope you can. Yeah, that's right. All right. So for my part, I will focus on the two big components, e-commerce and IP, which have been alluded by other speakers. So I'm not quite sure. I will be repeating, but I will try to sum up some of the key issues from a Vietnamese law perspectives. So talking about e-commerce, as you can see that, e-commerce provision under RCEP are very much general and fundamental. We can say here like 6 principles which are covered under RCEP. Number one, they talk about promoting paperless trading, e-authentication, and e-signature. And then among other things, it talk about promoting online consumer protection, including anti-spam, and promoting online personal information protection. And last but not least, it's also promoting the cross-border e-commerce by not requiring computing facilities localization and not restricting cross-border transfer of information by electronic means. So this is actually a quite key under the RCEP, which are quite fundamental. So talking about Vietnam, so we have quite complied with the most of the RCEP provision, and we can summarize what we comply with, and here are some of the key things. First of all, Vietnam has regulation on promoting paperless trading, e-authentication, and e-signature. However, when you talk about e-signature, there are still restrictions when it comes to recognizing the e-signature legal validity. So it's still untested before courts and authorities. Vietnam, like other country, we don't impose custom duties on e-transmission. I think that's a quite key thing. Some of the issues Vietnam quite ready, but again, changes are still underway. First of all, we have mechanism to protect online consumers. However, as you can see that recently Vietnam amended the e-commerce regulation by introducing Decree 85, amending Decree 52, and under which new obligation for e-commerce platforms, especially for cross-border e-commerce platform, have been introduced in order to protect consumers. And at the same time, we do have legal framework for e-commerce, taking into account the UCITRAL model law. So that's quite fundamental. This is non-compliance from my perspectives. Number one, Vietnam, so far we don't have a coherent and comprehensive legal framework for data privacy. Even though Vietnam is working on the first draft ever, we call the PDPD, it's called Draft Decree on personal data protection from PDPD. But then hopefully the PDPD will come out sometime in May this year. Will lay out the most fundamental legal framework for data privacy. And some of our speakers touch upon the data localization requirements here. Speaking from Vietnam, actually, we have the cyber law and cyber security, and it's quite interesting because localization of computing facilities, and cross-border transfer of information. So under our law right now, Vietnam still requires certain, entities to store data in Vietnam. It's quite scary. And however, the good news is in the VBF, Vietnam Business Forum, after the VBF 2022, the MPS responded in an official letter confirming that the data localization requirement will be very much relaxed, and only certain entities which do not comply with the request from Vietnamese authorities may be subject to data localization requirements. However, right now we are still waiting for the final draft of the decree implementing the law on cybersecurity, and that decree, once issued, will confirm on that point. Some of our speakers touched upon regarding the RCEP regarding the data localization requirement. And for Vietnam, actually, the current law on cybersecurity potentially is not in line with the RCEP, which prohibits parties, from requiring a covered person to use or locate, a computing facilities in that party territory as a condition for conducting business in that party territory. However, to maintain the requirement under the Vietnam law on cybersecurity, Vietnamese government has now relied on the RCEP exception that can still adopt in any measure inconsistent with the RCEP that it consider necessary to achieve a legitimate public policy objectives. So that is the exception. Moving on to IP, I have to be very brief because the RCEP, as you all know, it was built on the bones of the other important treaties like TRIPS or Berne Convention or Paris Convention or CPTPP or other FTA that ASEAN has entered. However, the good thing about RCEP is it has dedicated each entire section each for protection of genetic resources, traditional knowledge, and folklore, and also protection against unfair competition, even though those terms are still quite specific, unspecific. Some of the worthy, IP provision under RCEP and how Vietnam should comply with. I think I would skip this one because it's quite country specific. But let's move to one of the very important fundamental principles that one of our speaker mentioned about is the well-known trademark thing. So all notable changes imposed by RCEP may be adopted by Vietnam, amendment to IP law, which will be adopted very soon. But again, the good thing is under the RCEP, they will have to remove 3 criteria in determining well-known trademark that have been mentioned by one of the speakers before. So I'm not repeating. Bad faith filing, I think that's the big issue in Vietnam and other ASEAN countries. For Vietnam, right now, we don't have any clear guidance on bad faith filing. So that's why the RCEP is a key basic for Vietnam to move ahead with regulating the bad faith filing. So for pattern and design, I will skip this part, but I will talk a bit more about enforcement, which is quite key for Vietnam and ASEAN countries. So while the RCEP provision on criminal procedures and penalties are not as quite extensive as though regulated under CPTPP, the RCEP actually calls for criminal procedures for unauthorized camcoding in cinema. So I think this is quite key thing. And I think the agreement also confirmed the laid out civil and criminal remedies that must be available for infringement of copyright or related right and trademark in digital environment. So right now, I don't see any plan for Vietnam to amend the penal code to include this one, but maybe that will be comes into some of the subordinate documents. So I pause it here, and in case you have a question later on. Thank you.
Thank you very much, Mr. Tran. So we have ample time now for questions and answers. So I would like to start actually by just going back to the speakers and the panelists with the first round of questions. And I think we've got quite a range of perspectives. We've got the government perspective. We have also got the perspective from the private sector, and with specific focus on the regulatory and legal aspects. And I think since we have time, we might go back to some specific things which were perhaps not addressed in more detail, and speakers may want to touch upon them. So let me come to the first question, which is to Tamura-san. This is basically going back to the report that we have, which highlights the need to support ramping up digital infrastructure to more effectively use IP systems, widen e-commerce markets, and enhance SME capabilities and competitiveness. Given that the region has varying levels of digital readiness, how can RCEP respond and support ASEAN's vision of a digital ASEAN leveraging on the fourth industrial revolution?
Yeah, thank you very much. Very important, but a bit difficult answer to question. But my impression is that many, of course, the definition of the 4IR could be quite buried by the persons who use that kind of term. But if I could define them as a kind of term to, more progress of the industries by utilization of the digital technologies. Of course, RCEP and other relevant rules could have many things to support because without those kind of rule settings, like the free flow of data or location computing facilities, so forth, companies with advanced technologies would have some hesitation in enhancing their investment in the region. And of course, there are so many ASEAN companies now utilizing quite advanced technologies, like say those kind of startups in Indonesia or in Thailand and Singapore, but they need a kind of much closer alliance with the companies from China or Japan or South Korea, so towards a more effective operation. So those kind of rules in the RCEP and several other relevant agreements, including CPTPP and the ASEAN ECommerce Treaty or Agreement, could provide those kind of foundations for the ASEAN companies to be more equipped with the alliance with the those partner companies from the region towards the 4IR and other more advanced operation. That's my basic understanding.
Okay, thank you very much. Yeah. So basically what you're saying is that the RCEP agreement provides a platform, it provides greater opportunities for those kinds of alliances and collaborations for
Yeah,
companies
exactly,
in the
exactly.
region. And
Yes.
also because it will facilitate regulatory harmonization to some extent. So that will in turn also enable the growth of the digital economy and the exploitation of 4IR technologies.
Yeah, exactly.
Right. Thank you very much. May I pose the same question actually to Mr. Yap? If you could just provide your views regarding how we could use RCEP to leverage the opportunities that are there.
One key term in RCEP is partnership, and that means cooperation. So there has to be cooperation in activities that build capacity and knowledge towards achieving standards. So in many of the aspects that were listed in the primer of PECC, I think the bottom-up approach would be more relevant rather than try to impose standards from above than top-down. But that's where cooperation is critical. Remember, in the case of ASEAN, was it IAI, right? Initiative or ASEAN integration. I'm sorry, I've been out for a long time, but they've always been emphasizing that the development gap has to be narrowed for integration to be more effective. So RCEP has to adopt the same philosophy. Thank you.
Okay, thank you very much. Let me turn to the private sector representatives on our panel for their perspectives. Ms. Suen, I was wondering if you could just highlight perhaps what are some of the focus areas that should be prioritized to maximize ASEAN and RCEP regions' digital trade potential so that we can accelerate the shift towards an inclusive and sustainable digital economy, particularly given the recovery requirements after the pandemic.
Yeah, thank you. I think right now what is missing is data. I think people always assume tech company, fintech company, they have already collected a lot of data that would be able to use to power the cross-border trade business. But actually, it is actually very fragmented still, given various reasons. There's definitely different, regulatory regime. There's definite different public infrastructure set up in different parts of the country's regions. So, imagine a world if all these 15 governments can come together and agree what is the common data set that can be transferred and shared across borders like seamlessly in a cost-effective manner. That will be really helpful for the small players, who actually don't have access to financial systems, don't have, access to digital platform tools that they want to use. Because I think right now what we're talking about is how to make the process much simpler, frictionless, but also increase the accessibility for these SMEs to first, get the funding, get the financing they need to do business. So if I think the data itself, doesn't have to be a private property. It could be a shared public utility as well. So it's really a matter of the governments coming together and together with the private player who can bring the expertise to the table, and then to understand what are the meaningful data sets that should be looked into, and then how to build up a platform that can host these data so there could be multi-party interaction with proper protection and encryption technology in place to protect the privacy of these data to begin with the purpose that ultimately we want to benefit the merchants who wants to do business globally. So that will be my share.
Thank you very much. In fact, I was, going back to your intervention where you mentioned specifically about the validation of ID and credit risk assessment, the fact that there isn't information about the SMEs and maybe some cooperation among the governments and involving the private sector to understand how to do this and share this information across borders would probably be the starting point. So thank you very much for your perspective on the importance of public-private partnership to take forward the RCEP provisions. Let me also turn to our other legal representative here. We have Man Hung Tran. So if I may just ask you, just carrying on the regulatory and legal aspects, what is the legal trend that you're seeing in our other RCEP members? You mentioned the case of Vietnam. Are they opening up the market for cross-border e-commerce? And do you see them intending to amend their IP laws to comply with RCEP? That's another related sort of question on changing national policies.
Thank you, Rupa. Well, overall trend in the RCEP members is openness when it comes to like cross-border, e-commerce. So Singapore perhaps the most open one to the point opposing the restriction. So open cross-border e-transaction benefits Singapore a lot, because most of their company doing cross-border transaction. So that's why Singapore DPD PDPA provisions say that data can be transferred outside Singapore if it would be accorded a standard protection comparable to that afforded domestically by Singapore. We talk about data and adequacy requirement. So other members also have rules to restrict like cross-border transfer of certain categories of data, such as like health or some sensitive data like financial data. For example, like Australia, New Zealand, Japan and South Korea. So Thailand and the Philippines also promote to open a markets for cross-border e-commerce. However, they still maintain some vague rules that may interpret it as like localization requirements. So the member with at least as many restrictions like Vietnam, including like China, Indonesia, Malaysia, Brunei. I think Indonesia and Malaysia, they are moving forward to more leniency to support the market openness. China still maintains quite even stricter rules than Vietnam, as you can see from PIPR adopted recently. Last but not least, Laos and Cambodia and Myanmar. For me, I feel like they are still left behind when it comes to a comprehensive cybersecurity regulation, and therefore, while there are no explicit restrictions right now, but there is no certainty that in future they may adopt law to impose a bit more on that. In terms of IP law, as you can see, you heard from my presentation, Vietnam is amending the IP law. For Malaysia, I think as far as I'm concerned, they are amending the patent law to comply with RCEP. For other members, making amendments, to comply with RCEP does not seem to be under agenda. So more advanced economies like Australia, New Zealand, or Japan, South Korea, and Singapore, I don't think that they will have to amend the IP law to comply with the RCEP. Laos, Cambodia, and Myanmar, I think they allowed some certain transition period for a number of provisions. So they may be able to see more amendments in future. So last but not least, I think China, Indonesia, they just amended the IP law in 2020, I think last year and 2 years ago. So they don't have a plan to amend the IP law. But overall, I think only very few countries have to amend the IP law to comply with the RCEP. Back to you, Rupa.
Thank you. But just a follow-up question, this is also about readiness of countries to be able to amend. So what is your sort of forecast in terms of the ability of countries to make the necessary changes to align? How long will it take, and how much might that actually sort of slow down the RCEP integration process?
Right. Well, taking Vietnam as an example, they are very proactive in amending the IP law. And supposedly, I think the amended IP law will come out sometime this year to comply fully with the RCEP. So other countries, as I mentioned, Laos, Cambodia, and Myanmar, they are allowed to have some transitional period. However, I think they will making their way, some headways in order to comply with the law. Yeah.
Okay. Thank you very much. I would like to turn to Ms. Roy. we've talked about the enforcement issues and the importance of amending legislation. So the report has recommended economic and technical assistance in setting up an electronic application system to upgrade IPR legislation and enforcement, particularly for the LDCs. What is your view on this, and what specific areas of IP cooperation should be prioritized in your view?
Thank you. Let me just first situate this a little bit.
Sure.
If you think about the composition of countries, you would have a group of countries quite familiar with fairly robust IP provisions in trade agreements. And you also have a group of countries where the RCEP IP chapter was probably the first comprehensive IP agreement that they have undertaken in a binding form. And here I predominantly refer to the ASEAN countries. So looking at that as a sort of a context setting, I think in terms of prioritizing IP technical assistance, I think it will be quite cross-cutting for some group of countries, whether you're talking about things like enforcement or trademarks or patents and so on and so forth. I would assume that it would be quite cross-cutting for some of them. I think you would, for a group of countries, it would be basically understanding how some of these provisions interact with their own domestic legislations and where they want to go from there. And then for another group of countries, I would say it would be a bit more targeted. So again, maybe to borrow a phrase from one of our panelists, there's no one size fits all. I think it will require some depth of analysis to understand where the countries are, what the RCEP provisions mean for them, and then design fairly targeted capacity building for them. At the same time, it is also not just about understanding the provisions, but sort of ensuring there's longevity in implementation, and also making sure that the stakeholders, not only in government, but around the government, also understand what these provisions mean for them, not only in terms of compliance, but how they can actually use that in terms of pursuing opportunities in the region. I don't have a neat answer simply because it has to be individualized and contextualized for the very different country profiles we have in ASEAN.
Okay. Yeah, I understand. It really has to be very context specific. Every country will have to take perhaps an assessment of what it is ready to sort of align and how long it's going to take. But any sort of preliminary, when one looks at the range of countries and the differences in levels of development, which might be areas, quoting again from Mr. Yap, no one size fits all. Which would be areas which would render themselves more easily to a regional approach, and which would really need to be customized and taken country by country at an individual level? Which sorts of elements?
I think if we're talking about, I think there's value in having a regional registry and having the technology and platform behind that be explored further through capacity building. Where I think it's a bit more individualized would be things like enforcement, for example. So that's just to give a flavor of what might lend itself to a regional approach and what may need to be a bit more country specific.
Okay, thank you very much. Professor Gao, may I ask you the same question that I just asked Ms. Roy regarding the prioritization of areas for IP cooperation and your thoughts on implementation and the way forward?
Sorry, were you asking about IP or?
Yes, on IP.
Oh,
on IP enforcement and just basically how do you prioritize the areas for cooperation and how do we go about it given the differences across the countries? Yeah.
Mm-hmm. Yeah, actually, I research mainly on trade issues and not so much of an expert on IP, but I think in this region, copyright infringement is very common, and that is something that some of the developed countries like the US has been seeing for many years. So I really haven't looked at the RCEP in much detail. But I think one interesting new development is the rise of e-commerce nowadays, given that many of the digital content are provided online. So that kind of provided new challenges and opportunities also for IP enforcement. I mean, actually, in this region, if you look at the situation in most countries, most people would choose to get their content from online. And now what we have is basically a limited number of big platforms, like Apple Music, like Spotify, and so on. So that, I guess, ironically reduce the opportunity for IP, for copyright infringement, unlike the old days, where everyone 20 years ago was buying physical, CDs and so on. So I guess that is the promise of e-commerce. But another thing that is interesting, and again, this is also an issue raised by e-commerce, is the ISP liability. So whether the ISP would be liable if there are copyright infringement, if some body use the internet to provide the content online. And here I think that's something that ironically, again, in this region, what you find that some countries actually have stricter laws compared to, let's say, the US. In the US, because of the safe harbor regulation, so the ISP is not liable, but in countries like China, for example, they have a strict liability for the platforms, which provide these kind of services. So I guess, in the internet age, in the age of e-commerce, the old paradigms have been disrupted. So this brought new challenges, but also brought new opportunities for us to learn from each other.
Okay, thank you very much. In fact, I would like to continue with another question, which is specifically on e-commerce. We've had several speakers talk about ASEAN's e-commerce chapter and the DIFA negotiations. Now, one thing that always happens when you have groupings which become part of other larger groupings is the issue of coherence between initiatives that happen at one regional level and then when it's taken forward into another larger grouping. So what are your thoughts regarding the consistency and the coherence between what the ASEAN is doing separately in terms of its e-commerce chapter and the DIFA? In fact, a study is going to be done. You have the Bandar Seri Begawan roadmap, etc., and coherence with the RCEP. How does one ensure that you maintain consistency?
Yes, thank you. That's a great question, and that indeed is a major issue, especially as in the realm of e-commerce regulation. What you see is the rise of three major digital realms. You have the US, which prioritize free flow of data, and you have the EU, which prioritize privacy protection, and then you have China and the other developing countries which prioritize cybersecurity and also the regulatory autonomy. So I think there is a real risk of regulatory conflicts when a country is a party to several overlapping free trade agreements with e-commerce provisions. But at the same time, I also would like to remind everyone that the differences between different types of agreement might not be as big as some people would think. For example, I mean, you look at the RCEP versus the CPTPP provisions, as I highlighted in my presentation. I mean, there are differences on free flow data, on data localization requirements, and so on. But first of all, I mean, free flow data, many people tend to think that this is an absolute right for free flow data, to which I strongly disagree. Because even when you look at the CPTPP, the requirement is only that you are supposed to recognize supposed to allow the cross-border transfer of information when these activities for the conduct of the business of a covered person. So at the end of the day, we are only talking about a business data for a covered business. And the same is true for the RCEP. So to the extent that a country wishes to restrict data flow for a specific type of a sector, for a specific type of activity, the country can always explicitly note the reservation is a schedule saying that we do not include this in our liberalization of services or investment. So that is always possible. And also, I mean, in terms of the exceptions clauses under the CPTPP or RCEP, even though many people have been complaining that the RCEP is too lax in that it basically gives the invoking country the discretion in deciding whether or not it is necessary. But if you look at the CPTPP exception provision, which is basically based on the WTO rules, and if you look at the WTO jurisprudence, the WTO jurisprudence also provide a lot of leeway to the invoking countries to decide, what is legitimate and what is not. So at the end of the day, I would say that despite the differences in textual language, the differences between different agreements might not be that big. I think what is important for the countries is to try to compare the language of the different provisions and try to kind of upgrade their e-commerce regulations to as high standard as possible, as Mr. Mahon Chuan mentioned earlier in the case of Vietnam, for example. So I hope that with all these new free trade agreements, they can really be a major impetus in helping the countries in the region to upgrade their e-commerce regulation. Thank you.
Thank you very much for such an elaborate answer. Let me take some questions from the chat box. One question we have, any panelist who may want to answer, do we have a specific framework for settlement of disputes? Would any of the speakers or panelists want to take this question?
So may I?
Yes, please.
So I'm not so sure which chapter or provision you are talking about, but for the in general, of course, RCEP agreement has a dispute settlement chapter, and IP, intellectual property, is one of those chapters subject to that kind of dispute settlement procedures. And for the, but to be frank, it is not the usual case or the utilization of the FTA or EPA dispute settlement is not so many cases, and in many cases, and we gonna because maybe these kind of mega FTAs are the quite recent trend. So maybe those dispute settlement procedure in those FTAs have not been utilized so much. But for the case of RCEP, one of the very important character is in my presentation is the enforcement mechanism before getting into the dispute settlement. And we have 4 committees, 4 subcommittees, and RCEP joint committee, and bring the non-compliance or some kind of doubtful or alleged issues into those kind of G2G dialogue, and to find a way for the resolution. And we should utilize those kind of mechanisms towards full implementation or enforcement of the agreement. And of course, in relation to e-commerce, some and especially free flow of data, some of the countries' measures could be the subject for the discussion, and IP as well. That's my current understanding.
Thank you very much. There are 2 other related questions in the chat box. Within RCEP countries, if I register my trademark in Malaysia and it's approved, do I need to register in all other countries? Similarly, how about IP filing? Is my IP registered in Malaysia valid legally for all RCEP countries?
I'm happy
Maybe
to
one
take
of,
the question.
yeah.
Right. So, well, thanks, yes, Jean, for the 2 questions. My response to you is the RCEP is not like, it's not like a multi-mark, a system. We still need to follow the national law, trademark law in Malaysia and Vietnam to register your trademark. Only if your trademark become well-known in Malaysia, and then and in ASEAN, and then it may not be able to, you may not have to register again in Vietnam if it's recognized as a well-known trademark. If not, and then you have to follow the territorial limitation principles under trademark law. So again, it means you have to register trademark in Vietnam, Malaysia, and other countries. It doesn't mean that it will be automatically protected in those countries. So I hope that respond to your question.
Thank you very much for answering. So if the speakers would like to make any other last points, anything that perhaps they were not able to address during their intervention, we still have 2 minutes or so if you would like to just emphasize something important. If not, then I have. Yes, please. Yes, please.
Well, my last word is that, of course, our enforcement or implementation mechanism under RCEP is still under development and discussion. And our official level discussion should highlight more on that kind of issue. And in that regard, my sense of interest is on how we could gather the business interest or business concerns from the region on the enforcement and implementation issues, and towards future elaboration or amendment of the agreement. So I wish to communicate closely with relevant agencies, including ADB, to find a way to gather those kind of business interests and concerns from the region. That's my last remark. Thank you.
Thank you very much. I think we have a lot of useful takeaways from this session. I think I take away definitely the importance of having a more individual or context-specific approach to the implementation of RCEP provisions, the importance of public-private partnership and regular engagement with industry, and of course, the need to look at enforcement. That's obviously no agreement is important unless it can be enforced properly. So thank you very much to all the panelists and speakers for your time and for your excellent interventions. I hand over now to the ADB for the next steps.